everybody. Welcome here, everybody. It is such a beautiful day, and I'm so grateful for you to spend your time with us. You could be basking in the sun, and I hope you do that later on today. But we are here, and it is my honor to welcome back to campus Alex Peña, proud member of the Boston College Law School class of 2018. Welcome here, Alex. Alex has had an exciting career since graduating from law school, and this week he is back as the Rappaport Center's Senior Fellow. I think it's fair to say that Alex is a true Renaissance man with an astonishing breadth of experience which spans, this is not a complete list, voter protection, autonomous flying vehicles, AI, mental health care, corporate governance, immigration, and more. So let me fill you in on Alex's wealth of achievements. Before law school, Alex worked in the New York State Senate, where he was the Senate Democratic Conference Leaders Liaison to state senators. After graduation from Boston College Law School, he was a finance attorney at Morgan, Lewis & Bockius, working on very standard corporations issues of the same type you encounter in your corporations class, such as shareholder appraisal rights. Then he pivoted and served in the Biden administration as Associate General Counsel at the U.S. Department of Transportation. In that capacity, Alex gained deep expertise in cutting-edge transportation initiatives. Later, he led Pennsylvania's 2024 voter protection operation for the Biden and Harris campaigns. After the election, Alex returned to New York City to become the Executive Vice President of the Partnership for New York City, where he continues today. Meanwhile, he serves on the Executive Committee of the Hispanic National Bar Association. And to cap things off, City and State Magazine recently named Alex a legal trailblazer for 2026. Throughout his career, Alex's overriding goal has been to serve his community. That is his mission today at the Partnership for New York City, where Alex now serves. The Partnership is a very interesting organization. It was founded by David Rockefeller as a unique nonprofit organization to allow business leaders to work directly with government to tackle broad social and economic problems. There, Alex has moved forward a number of important initiatives, including New York City's successful campaign to adopt congestion pricing for drivers in Lower Manhattan. And as you probably know, under this program, drivers who drive into Lower Manhattan, I think it's during the work week, is that correct, pay a toll. That has reduced traffic noticeably while raising badly needed funds for infrastructure repairs. Alex has also spearheaded the Hudson Tunnel project and New York's new legal framework for regulating artificial intelligence. Last but not least, let me note that Alex is also a published legal scholar who has co-authored works with our own Professor Brian Quinn. In short, Alex's path is a model for every law student who wants to do well and do good. Before we turn to the main event today, let me also invite you to Alex's panel discussion this Thursday. So in 2 days, same time, same place. So this room, 12:15. And it has such an intriguing title. It is called Flying Cars, Drones, and the Future of Law. Lunch will be served for anybody who RSVPs, and you are also welcome to attend virtually. That event and today's event are both being recorded. Now, without further ado, let me give you Alex Peña, who will give his community address titled Legitimacy by Design, Governing in an Age of Distrust. Thank you.
Can everybody hear me?
Yes.
Good afternoon, everybody. I want to begin by thanking the Rappaport Center for Law and Public Policy for this honor, and in particular for Mateo and Pat McCoy for bringing this all together. I also want to thank the broader Boston College community, including the absolute best faculty in the world, for welcoming me back. To the attorneys and legal professionals here in person and joining remotely in the middle of the workday, I appreciate you making the time. And to the students with finals on the horizon and the world spinning faster than it ever has, you all make it easy for lawyers to find time in an impossible schedule. Thank you for being here. I want to begin with a premise that doesn't feel especially controversial anymore. We are living in an age of distrust. Distrust in government, distrust in media, distrust in universities, distrust in corporations, distrust of experts, distrust in technology, and increasingly distrust of the systems that shape everyday life, more than most people can name, explain, or challenge. But the argument I want to make this afternoon is more specific than that. My thesis is this: the central problem of this moment is not simply that institutions have become weaker or less trusted. It's that for millions of Americans, authority is now experienced less through institutions themselves and more through the systems that stand between institutions and the public. That is not entirely new, by the way. The New Deal bureaucracy was a system. Phone companies were an accessible system before the smartphone. Public schools are systems. Banks have long operated through systems. And even some of the most tragic features of our history, including Jim Crow, were systems. But in those periods, most people could still tell which institution was behind the experience and where a grievance, however resolved, belonged. What is different now is the scale, the speed, and the opacity, and the degree to which these systems often operate without meaningful democratic accountability. And when systems mediate power more directly than institutions do, legitimacy begins to erode. There is no obvious person to question, no clear place to appeal, no easy way for ordinary people to understand just how authority is actually being exercised over their lives. That matters to all of us, but it especially matters to lawyers. Because if you're trained in the law, you're trained to think about legitimacy through constitutions, statutes, elections, and courts, and agencies, and rights, and corporate policies, and shareholder governance, and fiduciary duties, individual rights, and of course, procedure. All of that still matters deeply. But for many people, authority is no longer experienced first through a familiar institution. It is experienced as a digital platform, an algorithm, a podcast, an influencer, a social media feed. So this afternoon, I want to do three things. First, I want to explain what I mean by the difference between institutions and the system. And second, I want to explain why that distinction matters so much in an age of distrust. And third, finally, I want to offer a concrete view of what governance should look like in this landscape, what the work actually is, with much more I hope can be explored through conversations over the next couple of days, including Q&A today. Of course, all these remarks are attributable to myself, not to my employer, or any other organization I am privileged to be affiliated with. So, when I say institution, I mean durable public civic structure through which authority is organized and exercised. The executive, Congress, courts, agencies, sports leagues, universities, major companies, news organizations, political parties, even churches, places of worship, unions, and civic associations. Institutions are recognizable. They have names and histories, leaders, missions, rules. They are places where we have traditionally located authority in American life. Systems are different. A system is how power actually reaches you. It's the machinery by which the institution and the person living under it. The rules, the processes, technologies, data flows, prioritization, rankings, and incentives to determine how information moves, how access is granted or denied, and how decisions are experienced in everyday practice. You cannot point to a system the way you can point to a court or a company or a government office. And that is precisely what makes systems so consequential. They are where legitimacy can begin to break down most quietly, because there is often no clear face attached to the decision, no obvious place to challenge it, and no real door to knock on. Now, to explain why I care about this topic, I need to tell you how I got here. And it does not start with where you might expect. And actually does not have to start with anything that was mentioned in the introduction. The best job I've ever had was working at Target. Not in state or federal government, not on 3 presidential campaigns, not at a law firm, not in advocacy for an organization that represents hundreds of companies in New York. At Target, the red shirt and khaki pants, just to be clear. I graduated from the University of Albany in 2010, where I had served as student body vice president, eager to put my political science degree to use. My version of that was walking into my hometown mayor's office in Suffolk, New York, and essentially saying, "Hi, you don't know me, but I just moved back home and I want to be put to work." The mayor sent me to an underdog state senate campaign, and I became the candidate's second hire. And we won, ending 40 years of one-party control of that seat. I was ecstatic, and I thought I had found my path. And then, instead of staying on that path, I decided that starting in the private sector made sense for the first couple of years out of college before I returned back to government. So I took a retail management job at Target. It was there, not in a seminar, not at a startup, not in government, that I gained one of the foundational insights that shaped how I think about American life. I spent 2 intense years at that company, often working 15-plus hour days throughout. I started in guest experience, and after 11 months, moved on to overnight logistics management. In my first role, I supervised about 40 people: cashiers, customer service workers, cart attendants, Pizza Hut, and Starbucks employees. Our job was to shape the experience from the moment a customer pulled into a parking lot to the moment they drove away. What I remember most about it all was how human it felt. On weekends and during holidays, you could feel the energy in the store. Young employees were forming relationships and becoming adults in real time, with fewer distractions during a given shift that one would have today. Customers talked to each other while waiting in line. Mothers and suburban housewives went window shopping on weekday mornings with a cup of coffee because phones didn't have that many distractions just yet. Overperformers were constantly assessing their promotion track because the possibilities in the retail workforce ecosystem were perceived as limitless back then. You could hear the walkie-talkies going off across the floor because people were actually asking one another for help instead of pulling out a phone to look something up or scan a barcode. It was communal in a way that's really hard to explain unless you lived it. When I moved to overnight logistics, I managed 65 employees, working 5 or 6 days a week, starting from 10 p.m. at night until the late morning. You broke the seal in the big truck in the back of the store. You opened the hatch, and my team started unloading 3,000 pieces, which means 3,000 boxes of product. Of course, those boxes contain more than one product. And at 2 in the morning, after we had gotten through replenishing half the store and stocking shelves, younger workers would meet in the break room and talk about what came next, what they were studying, what they were saving up for. And the older employees spoke about life and their families. It was physical, collective human work. And looking back, I think it happened during a pivotal moment in American life. The digital transformation from 2010 to 2012 was already underway. E-commerce was growing, but not quite there yet. Social media was rising, but it did not yet govern identity, attention, and public discourse. Self-checkout existed, but it was still awkward and secondary, forcing people to maintain human interaction. Automation was expanding, but the basic public experience of many institutions still had a direct touch. Those years at Target have stayed with me, not because I think retail was some civic ideal order, not because I'm interested in making nostalgia sound profound. They stayed with me because Target was not just a retailer. It was an institution that shaped public life, whether you were an employee or whether you were a customer. And every time I've walked into a Target since, it's felt a little less the same. That is true of much more than one company, of course. What changed is not that institution disappeared. It's that systems increasingly govern the experience between you and the institution. Something automated, impersonal, and difficult to understand its role in the grand scheme of things. The customer who once asked an employee for help now can look online and scan a barcode. The person who once shopped in a store can now do so remotely. The person who once got news through legacy media now gets it through a fragmented information system with far less institutional mediation and no shared set of facts to operate from. The institutions are still there, but the lived experience of it all has changed. And when authority becomes hard to identify, accountability becomes harder to enforce. And that is not a small problem. That is a fundamentally democratic problem that we're facing today. When the 2020 election ended and Joe Biden won, many Americans anticipated the country might settle back to something like normalcy, for better or for worse, regardless of what party you were in. Then January 6th came, and for a brief moment, it felt as though the institutions of American democracy were under attack, and they were. What is striking in retrospect is that everyone involved still understood power in institutional terms. The mob targeted the Capitol because it saw it as a place where authority lived. And those watching with grave concern looked to other recognizable institutions for a response: Congress, the presidency, the courts, law enforcement, and national media. Even in the rupture, authority was still being understood through institutions people could name. That pressure is ultimately what led to the certification of President Biden's inauguration on January 20th, 2021, which people tend to forget was truly up in the air until the very last minute. The deeper shift came afterwards, however. During the long COVID recovery, the relationship between institutions and the public did not just weaken, it changed in kind. Institutions were still acting, but the public increasingly encountered those actions through systems that made the institution behind them hard to see. Trust in universities kept falling, traditional media lost even more of its role as a common point of reference, expertise itself became suspect. Corporations often seemed to relate to the public less as institutions exercising judgment than as brands trying to perform the right feeling in real time. I will leave it to you all to determine how you think it all played out. Meanwhile, people became more isolated, more online, more remote, more accustomed to making judgments alone. Social media, e-commerce, direct-to-audience media such as podcasts, online influencers, and eventually AI did not replace institutions outright, but they became the systems through which many people increasingly encountered authority, information, status, and belonging. I think there was a window to respond to that shift, and it was during the Biden administration, where I was proud to serve, having been sworn in on day one at the Department of Transportation. But instead of directly confronting the deeper crisis of trust that was lurking in the background, government often focused on the immediate demands of the moment, as expected, many of them urgent and understandable. I say that with humility because I was a part of it. The executive branch was acting to reverse the perceived harms of the prior administration, as everyone does, each one does, and it was engaging in a set of deeply cultural battles that many rightly believed were not to be ignored. But even with all that happening, the distance between institutions and the public kept growing. That then became the backdrop of the 2024 campaign, of which I served. By election day, I had seen the consequences from an election protection standpoint up close. Disinformation was moving faster than facts. Voters were being taught to doubt the very infrastructure counting their ballots. Social platforms amplifying rumor and conspiracy before truth could catch up. Anonymous online threads spreading confusion in real time. Ballot tracking tools and election technology were essential to the process, but easy to recast as suspect. And a fragmented media environment that made it extraordinarily difficult to communicate clearly to a fractured electorate. The systems had fully arrived in that moment, and they were no longer underneath institutional life. They were out in front of it. And this brings me to the core idea of what I want to leave you with today. Democratic legitimacy is the reason people accept authority that they did not personally choose. It is not just that an election was held or a law was passed through the right procedural steps, or that a company took steps to change their behavior due to a legal decision. It is the belief that the processes and institutions producing those outcomes are fair, responsive, and accountable enough that people are willing to live with the results that they do not like end up. For us lawyers, we are trained to ask essential questions. Was the statute followed? Was the regulation lawful? Was due process satisfied? Was the agency within its authority? Did the court have jurisdiction? Was the decision arbitrary and capricious? Was the company acting on behalf of the shareholders? Was some fiduciary duty breached? Those questions matter, and they always will. But in that moment, they are not enough on their own. Because a process can become lawful and still feel impossible to understand. A decision can be technically correct and still feel impossible to challenge. A system can satisfy every formal requirement and still leave the person on the receiving end feeling powerless, unseen, and shut out. And those create problems for a democracy. And when it happens enough, the damage is not only legal, it is systemic. That is the heart of what I mean by legitimacy by design, part of the title of today's address. I don't mean public relations, I don't mean branding, I do not mean telling people to trust institutions more. I mean designing the exercise of power as lawyers and as citizens so that legitimacy is built into the way authority is now encountered. I do not think there is a master solution to the crisis of trust that we're living through. But I do think there's a direction, and I think lawyers are unusually well positioned to help lead it. That work can happen on two tracks at once. The first is making our institutions directly encounterable again. The question is not whether people must trust institutions in the abstract. People have never trusted institutions in the abstract. They trust institutions they can see, reach, and hold to account. Institutions where the name is attached to a decision. A reason is given for a denial. A human being on the other end of a consequential process can meet you where you're at, regardless of how it ends. What has eroded trust is not that institutions make hard choices. People expect that. It is that so many of the choices now reach people through layers of a system that make the institution beyond them invisible. So the work is not branding, it's re-engineering the encounter, shortening the distance between the institution and the person it serves until the institution is no longer something people are told to trust that they can actually experience. The second pathway is a little bit harder. It's building accountability into systems that were never designed to have it, inadvertently so. Systems where accountability infrastructure has not held up what the authority the system actually exercises in every day. It requires honesty about the tensions that I live in my role currently, where I represent 350 corporate investment technology firms in New York at the Partnership for New York City. So I'm not up here calling for every technical system to be put on the ballot or to be buried underneath regulation, particularly during a period where states and nations are competing to lead in AI and other emerging technologies. I have actively advocated against that outcome, and I believe rightly so because we must lead during this era. AI and automated decision-making are the clearest example of a challenge, though, that extends to any system exercising real authority in people's lives. So I will use it to illustrate a point. Here's what I've learned from the private sector side of this work. Responsible companies do not actually want the vacuum between systems and people either. When there is no clear standards, compliance becomes a moving target. Companies build and rebuild programs around ambiguity, driving up costs and pulling resources away from the actual innovation that is supposed to benefit consumers and the company. And when compliance is ambiguous, litigation becomes the de facto regulator, and that is no recipe for the success. So the answer is not regulation for its own sake, as has been the impulse for too many state legislators across the country during this era. The answer is sequencing. In my experience with AI regulation, the most productive path is to start with a gap analysis, identifying the real measurable vulnerabilities in how systems exercise authority over people in ways that disconnect them from the underlying institution. From there, you can develop guidance and principles to begin addressing those vulnerabilities, the ones that are driven by the disconnect and not already covered underneath existing law. And you start building real standards that everybody can get behind. With respect to third-party auditors, that market then develops organically around the standards and gains familiarity. And eventually, you arrive at a regulatory regime that is tailored, durable, and maintainable for this moment in time, not reactive, as we have seen, which is what has pitted many of the policy debates around these topics from the private sector against the public side. That's the reason why. That sequencing is not unique to AI, though. It is a template for any domain where system-level power has outrun institutional accountability. And it rests on the same principle that applies across every one of those domains. Wherever a system exercises real authority over someone's life, the old principles still apply. A right to know, a right to be heard, a right to evaluate the outcome. The question is not whether those principles belong in these spaces. It is whether we build them through thoughtful sequencing or wait until the gap between system power and the public accountability becomes too wide to close, and distrust is irreversible. That is where lawyers come in, because lawyers are often the people who can turn power into practice. So none of this is easy. I don't want to overstate what one profession can solve. We're not going to go back to some pre-digital past. We're not going to unwind modern complexity. We're not going to restore trust by demanding deference. And we should be honest that some of the distrust has been earned. But I don't believe we're stuck. I think people still want authority that can explain itself. They can live with a reasoned public sector or private sector related explanations for the outcomes. I think they still want systems that can be challenged. I think they want institutions that do not just manage them efficiently, but regard them seriously. And that means the task ahead is not to make power disappear. The task is to make power answerable again, to make it human where it is impersonal, to make it contestable where it's perceived to be closed, even if it's not. In the earlier world that I discussed, from 2010 to 2012, when something went wrong, people had somewhere to go, whether directly or at least conceptually. There was a face behind the decision, a process you could see, a person who could hear you out in the reasoning, a shared set of facts you could point to. That was not some golden age of perfect governance. It was simply what happened when distance between institutions and the people served had not yet stretched too far by technology, fragmentation, or complexity. Rebuilding that, not the specific world, but the basic relationship between authority and the people subject to it, is not a communications challenge. It is a design challenge. And design is what lawyers do. We draft the rule, we structure process, we decide what must be disclosed and what must be heard, what gets reviewed, and where responsibility lives. Every day, in ways large and small, we convert institutional power into lived experience. Which means the question for this room and those joining remotely is not whether you care about legitimacy. It is about whether you will treat it as part of the job, and not an abstraction you study on an exam, but a design constraint you carry into every system you build, every process that you structure, and every institution that you advise in your professional life. If we do that, then legitimacy does not have to remain a memory from an earlier era. It becomes a project of this one. Thank you.
Thank you very much, Alex, for your remarks. We are really excited to open up the floor. As you know here, we always begin with our students first. So hoping that a student will start us out, and then we will open the floor to other questions as well as to those who are online.
Hello, thank you for being here. My question, I suppose, relates primarily to the low emission zone, but then more particular, you're trying to push policy objective. How important is it to rely on similar or existing policies around the world? I mean, for the low emission zone, the one I think of is London's, and that seems to have been very successful. So, do you find that you're often relying on pre-existing similar policies around the world or around the country?
That's a great question. I think the answer would have been different probably 10 years ago. But I think today is, and it kind of ties into what I'm talking about, which is you start off with an automatic discomfort with an existing policy or statute of law that is observed outside of our modern kind of American democratic system. So in the ways in which you want to, as an advocate, as a lawyer, as a policy person, to bring that into the fold, bring that into the mainstream, bring that into your state, or try to advocate for it federally, you have to build comfort around it. You have to build a level of trust around it. Back there used to be, Supreme Court precedent was different about this, maybe 10 years ago when you would cite something, international law depending on the justices. But I think practically most of the actual changes that are happening right now are actually happening more locally. So states, instead of federal government, right, are observing different types of policies and standards from abroad, and they can do that within their constitutions. And so then, so that doesn't go up against federal, but how they do that, they still have to convince their existing body, their legislature, their voters, their community, their state about what that means. And so, I think it's probably still the issue still remains, which is trust, but I think it's less about making the case to a court and more so about making the case to the public when it comes to bringing these type of standards globally back home. I think folks are now, because information is so accessible, it's no longer foreign, so you don't start off like at kind of from zero. People already have preconceived notions about what they view in other societies, other economies, and so they're going to have ideas, and so it's up to the advocate to figure out where am I starting in my state, or where am I starting with the stakeholder, and then how do you work back and get it to a point where it's trustworthy, as opposed to maybe when I was in your shoes 10 years ago, I would have thought about how you present it and how you talk about it from a presidential standpoint to SCOTUS, right? But I think honestly a lot of more stuff is happening locally, and so therefore the trust is in the people, or trust is in the legislative body and the state legislature, which is far different obviously than Congress, when there's much more national equities involved.
I'm sure as everybody listened to you in the room, one of the thoughts that crossed our minds was the lack of accountability of AI. And I was curious if you could talk about how you create accountability in an AI system. And let me throw out two possible hypotheticals to play with. One might be the consumer who interacts with a chatbot that is powered by generative AI and has a frustrating experience with, let's say, some sort of consumer problem. The other might be a loan applicant who applies for a loan and is denied based on AI underwriting and is trying to get an answer as to why they were denied and trying to get a reversal of that decision. Do you have ideas for how to make either of those humanly accountable?
I think, starting with the second one, so about, where AI gets brought into making decisions, right, or assisting humans in making decisions, whether it's a loan application or an insurance or a rate or a premium, that is something that's very much live, and there's obviously no good answer for it right now. But I think the reason for that is because at this point, because of the fact that systems are such an overwhelming part of our life, we're starting with consumers when they engage, particularly suspect consumers, whether they be an employee or whether they be somebody trying to get some sort of benefit and they're applying for it, with complete distrust. And then we have to work back from that distrust to explain to them how these extremely complicated systems that run every part of our life, major predominant roles, unlike they ever have, how they actually do play out. And oftentimes, when it comes to state legislation, there's always, whether it's algorithm discrimination, the starting point from the state side is like we need to stop it dead in its tracks, right? To start with kind of the punishment portion of it, which is to say, you need to, if you're going to do X, Y, and Z on the front end, if you're going to use the system, you have to get it audited. You have to do all these different types of things that basically make it unmanageable and don't make it fun or accessible for the consumer. And then you put a pitfall because the state is saying, I don't understand this, so you have to stop it. And the company is saying, we're following by the rules that there actually are processes for this, but no one understands it. And so we have to both inform the consumer, and you also got to inform the state. So part of the solution is not only intense education, but it is starting from an understanding that there's great distrust over the complexity here. And of course, as a public servant, you're going to want to stop it dead in its tracks. And as a company that's competing, with other states and geopolitically, you're thinking I've done everything I could. And if you can identify areas that I can improve without disrupting my work stream, then I'll do it. But otherwise, what you're doing doesn't make any sense. And so a significant amount of time is spent with those kind of clashes in terms of the system that has an impact on a consumer. Oftentimes, 9 times out of 10, they really are answers in ways in which either something's already, that there is accountability occurring, or it could be explained a little bit better, or it could be brought to the forefront for a consumer without it damaging the process for for not only the AI company, but a traditional company that uses AI, whether it be a bank, right, or insurance company. So that's the second question. I think it's just a schism between the sorts of distrust. The first one, about chatbots, and that's a big one for another reason, which is about accountability, right? And so now there's this kind of philosophical debate about, when you engage, whether you're seeking professional services, whether you're seeking advice, legal or medical, where does accountability start and end? And I think that is a question that, because we're in this rapidly developing era of AI, folks haven't slowed down to really flush it out in spaces where there could be meaningful dialogue. And so what happens right now is that you have a bunch of stories, right, and then you have a misunderstanding, and then you have everybody looking to find accountability. Oftentimes, that accountability will look like layering it on the private sector, right, via a nascent auditing third-party market, right? You say, hey, you need to pass an audit by some company that hasn't really had time to build up an industry in audits because it's still a very nascent industry. And so we're gonna stop you dead in your tracks because you're gonna have to get an audit, and it's gonna be very difficult, right? So that stops the company. Or we're gonna allow a private right of action to exist so that anytime someone has a bad experience, they can go straight to court. Now, of course, if you think about it on it by itself, that sounds like that makes perfect sense. Everybody should be able to go to court if you're wrong. But the problem that happens in emerging industries and nascent industries and industries that are hard to understand is that those private right of actions get abused left and right, particularly in highly litigious states, and it creates all sorts of problems for not only the economic environment but also for the legal system itself. And so then you're like, okay, well, there's third-party auditing, that gets out the company. Maybe we put a private right of action, and so we have kind of fiercely advocated against those at this moment in time. And then there's the other part, which is how can we allow government, how can we explain to government, particularly in the state side of things, where accountability starts and where it ends, and have an actual dialogue about that for the public to consume. I think oftentimes we expect that the public just wants an immediate answer and they want somebody punished, but oftentimes, like I explained in my remarks, the public just wants an understanding of where power resides and how it's going to be used, and they can live with, obviously, exceptions on either side of the spectrum, they can live with the outcome as long as it's being delivered directly to them. That could be applied for AI, that could be applied for, a company that's putting out a project and they are doing an environmental study and they say, hey, listen, we've gone through the steps, there's some issues here we're going to mitigate, we can't get it all, but because of what we've done, we believe that ultimately the project's going to be good for the community, and this is where it's at. If there's more advocacy lived there, there would probably be less pushback and less litigation over things, because the public would not have an appetite. But because there's distrust, because there's complexity, because there's a lack of awareness about how this works, oftentimes you get an environment where private and public sector are pitted against each other, litigation emerges, and everybody tries to find the answers. And it's no secret for the AI side of things that there is no system yet in the country on the state side that there is no strong regulatory regime on the state side in the country right now for AI outside of the consequential use AI, where you're spending a lot of money and there's obviously an impact either on national security or on life or on a whole host of things that are kind of reserved for a much more select case the use of AI. But otherwise, there is no state regulatory regime for AI right now. It's because of what I've explained, which is the pitting against each other, which I think can be worked out both by building back trust and then by just telling it like it is and saying, this is our system, this is where authority resides, this is where it starts, this is where it ends. And if you go from there and allow the public to consume that and allow the legislators to figure out where they land on the political spectrum on it, I think ultimately you will get an outcome and people will live by it the same way they've lived by every other technology that has hit the market over the last 100 years. And so that's kind of how we think about it. Obviously, we're in the stages right now where New York, like California, is the epicenter of trying to test out some of these policies and regulations. And so it's been great honor on my end to be part of it, but also to realize that a lot of this stuff really is either misunderstandings, starting from a place of distrust and not realizing that, and or not taking advantage of the fact that if we just explain to the public, hey, this is where we landed on a particular area of liability, that eventually people would revolve around it and those issues would resolve and we'd be able to move on, and the companies wouldn't be able to always throw up their hands, rightfully so, and say everything you're doing is getting in the way of innovation, it's not actually delivering any real results, it's just really stifling our impact in the state, our impact competitively, and so that's where we're at right now. So that's kind of how I think
it.
about
Thank you for coming. I just had a quick question about how you look at government responsiveness. I'll use for an example the Biden infrastructure bill. The Biden administration and Congress do this massive...
Yeah, I'm going to have you from that anyway, because
oh, okay. Sorry to the folks on Zoom. Okay. The Biden administration and Congress do this massive reinvestment in American infrastructure, and then it kind of disappears. The results of that don't manifest by the time the next election comes down. It's not communicated very well. Is that an issue that is explainable by your framework? Is it explainable by individual presidents' failure to communicate? I'm curious to get your thought on it.
Yeah, that's a really good one. I was part of the infrastructure law bill drafting, obviously from the general counsel standpoint at the Department of Transportation. and was there when it was passed, and then was there for about a year and a half of implementation before I left in September 2023. So definitely an appropriate question. I've spent a lot of time thinking about it. You know, like anything, you know, the answer is split between a couple of things, but I think it's important for us lawyers to realize that that's how it's going to be in this era, and it's why I focus the remarks around systems, institutions, and trust and distrust, because that's how we're going to operate as professionals moving forward. We're not siloed into categories, like this is my practice, I don't do anything else. The world is globalized, like we're all going to be part of it. We're going to have to work through consumer distrust, we're going to have to work through government dysfunction, we're going to have to work everything in between. And so when I think about what happened with the infrastructure law, you know, I think part of it is understanding that, like, you know, when the president picks what they want to do in their first term, you know, it's one of the biggest decisions they'll ever make. Sometimes the results are immediate, sometimes they're not. In this environment right now, where people are moving fast, there's distrust, there's a lack of respect for institutions, picking, I think rightfully so, picking infrastructure might have been the right move, right? But those results were not going to come fast. You don't build a bridge in even 10 years, right? You know, obviously one that connects to substantial centers. And so how do you prepare for that in an age of distrust, in an age where the public has shut out and they're consuming from the systems as opposed to consuming from the institutions, right? State agencies, port authorities, you know, federal government, private sector industry, grants, you know, approval process, environmental approval process, interagency processes, right, where, you know, DOT might have handed out the money, but the Department of Interior and Department of Energy have something to say about it. Oh, and maybe, you know, and maybe telecommunications as well in Commerce. So it's like those things we have. I think there was probably more hindsight is 2020 that could have been done thinking about from a communication standpoint about what this looks like, but why it's right. That's one part of it. The other part of it is that, you know, when you're in an era where, you know, Congress is fractured and there was an urge to, you know, basically as soon as he came in to kind of flip and obviously to, you know, to get back the White House in 2024, everything that was going to be done was going to be on the table. It was going to be on the chopping block. So when you think about all the money that was given out, you have to make sure that when we're educating folks about it and when we're trying to, from a political campaign standpoint or even from an accountability standpoint, that we let folks know about the realities. And the realities were that, you know, a lot of that money, even if it was out the door, was not going to be able to actually make meaningful, visible change in the community. It might have made, you know, structural changes and put in place, in motion, many important projects from an equity standpoint, from an environmental standpoint, from a transportation movement standpoint, to make our states more accessible. All those things might have been true, but the fact of the matter was it was always going to be risky because of what could happen if Congress would stop the funds or if another president came in and took it off the chopping block. Now you might say, well, what about Obamacare, right? And I think, as you've seen, there's been many tries, but some of those, it's harder to unravel as it's proven, right? Since 2011, it's harder to unravel a healthcare system put in place than it is to unravel grants going out the door to build, right? Because you can stop those grants legally, you can stop those grants functionally. They can go out, but you can, like, you know, you could say that you could change the guidance, you can make it difficult to actually use it, right? Whether it's an agency coming down on you or whether it's an advocacy group suing you saying that's not what the funds were for, right? You can do all these types of things that can functionally stop hundreds of millions of dollars from actually making an impact. And I think at the end of the day, we have to realize that moving forward, wherever we pursue next, whether it's immigration reform, whatever it might be, that the public needs to understand that in this fast-paced era, that it's got to be a collective effort right now. And there's too many levers to be pulled because the parties, the outside forces who want to oppose something will know that they're starting from an advantage point because the public does not have that same type of vested interest in the past, and they're much more likely to allow these types of things that can happen, and allow, meaning that, like, you know, funds being frozen, you know, agencies kind of, you know, ignoring what, changing up guidance, maybe, you know, skirting the lines, or concerted efforts on the ground to stop the actual money from doing what it was set out to do when it was allocated to that State Department of Transportation or to that Port Authority. And so that's my thoughts on it. I know a lot, you can read all sorts of articles about, like, you know, hey, it was a mistake, or it was slow and it should have done better and they should have put more people on it. It wasn't that. I mean, we work day and night, not only at DOT, but also all the other corresponding agencies. It's just a function of federal bureaucracy and an era where people have pushed a lot of the, get things done to the state side because they want to see results more quickly. And so that's why states have been more active, right? They've been more active because they can pass laws and say, look what I did. Congress takes a long time to pass laws. States can introduce 2,000 bills, 3,000 bills a year, and they're taking off every constituency, making this person happy because they can say, look what I did, even though it might not manifest anything. Different at the federal level where people see a lot of money, you start from a point of distrust, you don't see the money transform to anything in 2 years, and all of a sudden people are like, stop it, you gotta let it go. Stop the funding, it's not actually working. What is working, it's just different, right? And so I think that's kind of how I approach it.
Thank you.
Is it okay if oh, there you go, sorry.
Alex, thanks so much for coming back. I'm curious as to what your proposed legal framework is for making corporations more accountable to the public. Because of course they're accountable to consumers and they're accountable to shareholders, but a cynic might argue that Project New York is an association of corporations who are trying to influence New York policy and regulations for their own benefit rather than for the public's benefit, basically a lobbying organization. So I'm wondering, in your experience in corporate law, what changes can we make to the law or the regulatory environment to make corporations more accountable to the public?
So, and I'll back up by saying it's a good point, right? So I work for the partnership in New York City. We represent 350 of the biggest firms in the city. It was a Rockefeller project, and it was set up so that it would be able to allow a private sector to also be part of the solutions for New York, because New York was essential. New York City was essential for New York State thriving, and so therefore the private sector had a role to play. You had to keep New York City thriving across the board. And so that organization weighs in on a whole host of things. Weighs in on not only corporate legal frameworks and regulatory regimes and taxes, but it weighs in on mental health issues. It weighs in on public safety. It weighs in on fiscal responsibility. It weighs in to some extent, it weighs in on infrastructure projects, whether it be MTA or whether it be the Gateway Development Tunnel Project, which is the building of a new tunnel between New Jersey and New York to supplement the 100-plus-year-old existing one. So we do all these types of things as we always have as an organization since the 1970s. And then the question is, how can there be a role played to make corporations more accountable? I frankly think that, having worked in a law firm, having worked now at the Partnership in New York City, that a lot of what can be resolved and helping actually put together regimes and structures in place at the state level that can satisfy both legislators and the general public that the corporations fit between some regime in state corporate law can be done by not necessarily writing off corporations at the beginning. And what I mean is, right now, a lot of the debate, of course, because the moment we're living in, they start off at a deficit, so they start kind of defensive. Oftentimes, when it comes down to a bill being introduced, and let's say a bill is focused on how non-competes or other labor law issues or AI regulatory regimes or consumer protection laws. Oftentimes, if you really push and you work with the companies, of course their first reaction is going to be oppose it. We don't want to get involved, right? Because they're paying taxes, they're heavily regulated, particularly in states like New York, California. So they say no more legislation. That's always the starting point. But in my short time, like a year and about 3-4 months at Partnership, I've often challenged my counterparts at the companies to say, listen, the political realities is that sometimes these things are going to come to the forefront. So we need to play a role here. How are we going to think about talking about non-competes and saying, hey, this is where the line should be drawn because it actually is disadvantageous for New York, disadvantageous for the actual employee? How are we going to talk about certain labor laws? How are we going to talk about consumer protection and explain that, the knee-jerk reaction to, up the ante and just say that anything and everything you can be punished by the Attorney General because some practice is deceptive? Why don't we reel that back and talk about what we can live with, what we can understand, what practices you're currently doing that you think fall within the constraints of the law, and say, hey, that's going to be the line drawn, but other areas we can be flexible. And so I say this to say that I actually think, and it's the reason why I took this job. If you look at my background, it's no secret that I've had a long career in public service. It's because I like hard things. And right now, in this era right now, we have to bridge the gap between the public and the private sector. And it starts with meeting them where they're at and not, and not kind of settling for the, we're not going to do this because they're regulating us, or we're going to punish them because they don't understand and we need to deliver something for the individual constituent. It can't be that way anymore. And so, Professor, I think, I have one example. There was a consumer protection law last year that had been proposed for multiple years, and every year it got close, and for some reason it didn't pass both legislatures. And then eventually, last year was a year in which there was momentum behind it, and so I had to have a hard conversation with our member companies about what this looked like, where the lines should be drawn, how we should be advocating, and how we would truly actually figure out a way in which this bill can be put in a place where it would not be detrimental to companies operating in New York for practices that we did not believe should be either civilly or criminally punishable, right? And we got to a place. It took like 10 months of negotiations, and eventually the bill was passed, as I predicted. And we got to the drawing board about like explaining to both houses, explaining to the governor's office where we and other, of course, other organizations, how we viewed the bill, how we viewed the detrimental, what should and should be done, and there was all sorts of back and forth about adopting different types of state models, this and that, and eventually we landed in the place where, of course, you ask our members, they're not going to say that they're writing home about it, but I think we landed in a place where we can move on with our life, and the businesses can move on, they can adjust something internally on the regulatory front, they can adjust how a particular product or service that they might have thought fell subject to that regime. They can make an adjustment, but because the bill was not unwieldy, because it did not lead with punishing, we got to a place where we were able to say, okay, that law is not going to come up again. We updated our consumer protection laws. That's done with. We can move forward. And that's a result that should be talked about more to voters. And I think that's a result that should be emulated more when it comes to trying to put together regulatory regimes or trying to impose anything on businesses in this environment right now where they have every right to be on the defensive. And by they, I don't mean the business, I mean the people who are in the legal departments, in the policy teams, the people who are front-facing for the companies. You often realize, maybe it was like 2009, 2010, you could talk easily about corporations, as kind of like invisible beings. And obviously, that should never be the case. There should be accountability. But I have found working, whether it be a law firm, particularly in this role, that oftentimes the pushback to a new regulation, a new piece of legislation or regulation that we have a problem with, is not like done by the CEO sitting in the room. It is done by lawyers who are thinking about how they can best serve their business. And it's done by policy folks who are thinking about how they can best make sure a product succeeds. And so we have to, when you think about it from that standpoint, I think we can get much more solutions done at the state level when it comes to creating an ecosystem where everything is balanced. And it might not make everybody happy, and there's going to be times where, there's a bill and there's nothing we can do about it, that this doesn't work. At other times where I will try my very best to make sure that we give every chance possible for the legislature to hear where we have to go. And ultimately politics wins sometimes, but sometimes we land in a good place, and that was one example where there was a new regulatory regime placed on the private sector, all the private sector in New York. We found our way in to make it not existential.
Thank you so much, Alex. What does it feel like to be back in the hot seat with the podium professors who are asking you the tough questions?
I had a feeling that professor was going to ask one.
Professor Cassidy and Professor McCoy, you're supposed to make our alumni feel like they've achieved grown-upness at this point, right? Yeah. So thank you for asking them the tough questions. So Alex, for reasons unknown to me, we were not lucky enough to get you as a Rappaport fellow, a summer fellow, when you were in law school. We have a bunch of Rappaport summer fellows here now, and I'm sure that, like me, they're kind of feeling like, wow, this guy's done a lot. a lot before law school, he's done a lot since law school, and we feel really, really lucky to have you be a part of our Rappaport community now, even though we didn't get you when you were here in law school. And I kept thinking as you were doing your talk that that's a real shame, particularly because I think Jerry would have really enjoyed meeting you, because your emphasis on building our capacity to connect with one another and using that capacity to generate good policy and meaningful impact in the world, I feel like that's exactly what Jerry was looking for when he created the Rappaport Fellowship and also endowed our center. So I'm really grateful to you for continuing to steward that vision for Jerry and now becoming part of our Rappaport family in your mid-career. I would really hope that students are going to take that challenge of how do we do design in a way that bridges community, public officials, and create legitimacy in those structures. And I hope that they'll take the first step of joining us on Thursday for your incredibly exciting panel on advanced aviation technology. Because certainly as new technologies take flight, sometimes much faster than our legal frameworks do, we're confronted with the same question that you asked today, which is how do we build systems that people can trust, and how do we design governance that enables innovation and creativity, as well as ensures that the community can be safe. So everybody, we hope you will join us on Thursday for this incredible panel. And I hope you will take the time right now to join me in thanking Alex for being here today for that incredible, rounded talk. And he's here for 3 more days, so we're very lucky to have him. Thank you, Alex.